Appeal Tribunal for Competition and Market Authority of Allergan Plc.
Good morning, Mr. Greeley.
Good morning. Good morning. I'm just going to be 20 minutes and I'll let everybody else take over from me. I would just like to finish what I call the 50% point. And then I just want to go to some of the documents that show the 50% point as well. And then I'll let Mr. O'Donoghue take over in about 20 minutes' time. So please forgive me if I kind of rattle through some of the references. We were in the agreed supplemental bundle. So if we could go back to that, please, the agreed supplemental bundle. We had seen one passage. Could we go to page 483? That's 480 of the old hard copy. So 480 of the old hard copy, 483 of the agreed supplemental.
What tab is that?
That's tab 6. So this is day 2. So tab 6 of the agreed supplemental bundle. It's my tab 6 anyway. I hope it's.
Hang on, it's actually in volume 1, yeah.
It is. It's volume 1. Yes.
This is Mr. Baton, is it?
Mr. Baton, yes. Right. I just want to.
Page, sorry.
I beg your pardon. It's page. Oh, it's. I think for my lord it would be 480. Internal 168. Internal 168.
Yeah.
So in line 24, this is where he's giving evidence on the. It's a question. You thought it was a mistake. Line 11 is his evidence, really. Yes, but unless he thinks I am completely bonkers, why would I not launch my product as soon as I got access to 40,000 packs a month? I promise you that the economics of this I would have are hugely in favour of launching my own product. And
sorry, I can't see that on line 11.
It's page 481.
Sorry,
I'm over.
It's the next page. I beg your pardon.
483.
I'm going too quickly.
What? Yeah,
so,
on yours, I think.
484, yeah. Okay, thank you.
I'm sorry. So, page 169 of the internal, from my Lord Master of Laws 484,
yeah,
line 11 to 15, he's saying, unless I'm completely bonkers, why would I not launch? And then the question is, Mr. Baton, we will take that, we will come back onto that, we will take that in sequence. And we see in the judgment in H3, the tribunal say, well, that wasn't challenged, and it wasn't challenged at that stage, because the questioner wants to take it in sequence. But there's no pushback on that at that time. Then if we go to...
What's the paragraph number in H3?
The paragraph number in H3 will be essentially paragraph 103 sets it out, and paragraph 104 the tribunal says the assertions are left to stand unchallenged. So it's paragraph 104, page 364 of the judgment.
But the reason why it wasn't challenged then is because Mr. Dimitriou says in the very next question, she's going to come back to the issue of the economics of it all.
Yes,
and she does come back to that. There's a whole chunk of evidence about that on the second day of his evidence. About driving the market down and where you position yourself in terms of, do you go in at the same price or do you go in at 15% lower or whatever, and the problem of potentially, as it were, driving each other down price-wise so that they both lose out. So it's an issue that was explored.
But can I take that in stages? So there's undoubtedly Mr. Dimitriou did put to him that there would be a spiralling down of prices. Now the first point to say in response to that is contrary to a passage in the infringement decision itself. So the CMA in the infringement decision itself says that on a first generic entrant there will be no spiralling down prices. And I can give you the reference to that. So, and this is support for Mr. Baton's coherent. If we go to that, if you want now, that's core bundle 1, tab 11, 547. Potentially we should see that.
Sorry, could you give the reference again?
Yeah, so the decision, that's it's at page 541, so that's core bundle 1. So I do accept, my lord, that Mr. Demetriou said, well, there'd be a spiralling down of prices. He says no, but that's not the way the market works. If we look at what the CMA said in its own decision at 356, this is 547, usually, this is paragraph 356, 547, usually generic entry into the market is phased. Initially there may be competition between generic entrants to be the first to enter. It is expected that the first generic entrant will obtain the highest profits as it only needs to price slightly below the incumbent, assuming that the incumbent does not compete on price straight away. Other generics might enter the market at a later stage, and it is typically with subsequent entry and the initiation of price competition in the market with multiple generic entrants that price competition becomes fiercer. And it's that is...
Sorry, this is a general statement, not a statement about the facts of the case.
No.
Well,
Just looking at the footnotes, this comes from the Commission's sectoral guidance and their next similar points made in relation to the auxiliary.
It's also assuming that the incumbent does not compete on price straight away, which is an assumption which may or may not be correct on the facts of any given case.
yes, so can I just...
Mr. Demetriou put to it was precisely the point that Ford and Mackenzie would have competed on price, on that hypothesis, which he's perfectly entitled to put. It's not contrary to a finding of fact in the CMA's.
But it's going... I do apologise, but it's going to advances Mr. Baton's state of mind in 2013 and whether he's being paid to delay his product. This is the critical issue, whether he's being paid by Auden to delay his product. And he's giving what the tribunal said was coherent evidence that it was bonkers to say that he was being paid to delay his product. Why? Because, as we saw yesterday, he wants to get in early, he wants to be the first mover, have first mover advantage. And if we just can I just it's in response to the President's question. So if we go to, I think it's 565. No, hold on.
Next day,
It's 569. It's 569.
in what?
569. So I just for the court's note, there is further evidence he gives at page 468 and 491, which we maybe should have a look at. But this is at 570 of the electronic.
That's the next day, isn't it?
It is, yes. This is the next day. So this is the evidence he's given in exchange with questions to the tribunal. So this is tab 7, page 5. Well, he gives the evidence at 570. There's a bit before that, but 570 of the electronic. So I think it's 567. Yeah. And this is important because this is what is in his mind in 2013. Typically, what happens in these circumstances where only one competitor comes to market, and this is, remember, I am a generics guy, so I'm used to bringing these products to market. usually when a patent expires, there are 10 or 12 competitors coming in at the same time, and the market immediately shoots down to barely above cost of goods. In a situation like this, where only one competitor comes in, clearly depending on how rational that competitor is, he or she, me, would have come in with hydrocortisone, for example, at a discount of whatever I felt was needed to take half the business. I would not go for more than that for rational reasons, because I did not want to see the competitor backlashing in some way, and then ending up in that downward spiral just between the two of us. So I would take 50% at let's say, 10 or 15% discount.
And then he goes on to say there's obviously a danger, however, that the incumbent will fight back.
There is a danger that will fight back. And he goes, okay, so there is obviously always a danger that Ord and Mackenzie in this circumstance starts fighting with me and we end up just at cost of goods. But I do not think that would have happened. That sort of thing usually happens when the competitor does not really care too much, or they've got so many other products. They've just got junior product manager looking after them. In this case, Mr. Patel would have been very eager to have maintained the value in his business, I am sure. The President says so. So, Mr. Bates, so do you see what I'm trying to say is that the price in this case would not have dropped substantially. You would not have had the spiral down to just above cost in your view. Yes, exactly, and I think it is a proven view with lots of evidence supporting that does not happen with two competitors. So putting ourselves for a moment, and I appreciate that we are speculating here, in Auden's shoes, they might, if your product entered the market at say 10 to 15% discount on their price, they might have stuck at their existing price, yes, provided they maintain their 50% market share on that basis, exactly. And this is very, very important because this, and I may make no criticism, but the CMA did not challenge this evidence. And the tribunal said that this evidence was coherent. Can I just go to a few passages of the judgment, perhaps, just to explain why, where the tribunal said that this evidence was coherent? And but in Mr. Baton's head, he is not being paid by Auden to delay his product. He wants to, as we saw in the Deloitte report yesterday, he wants to get in early, have the first move advantage. And the tribunal, and Mr. Mitri, to be fair to her, she did say spiralling down, but that was contrary to what actually the infringement decision says, and he denies it. But if there's no spiralling down, there will be a 50%, and that is not challenged. What is challenged, what then goes on, my lord, is that the CMA then say, well, you had a forecast of 10,000 in late 2014. And Mr. Baton says, well, yes, but that's because the orphan designation skewed the market. So we basically had to downgrade our forecast. But the really important, one has to remember that there is an allegation that Mr. Baton knew about a pay-for-delay type agreement in late October 2012, throughout 2013, and he's saying that just does not make commercial sense. And the tribunal was quite entitled to accept that, particularly when the tribunal thought it was not sufficiently challenged. And it is a coherent explanation because we see, he says in answer to the question, typically, well, yes, typically the CMA say that in their own decision. And can I just, I mean, there are. I'll give the references, but can I just go to a couple of passages in H3, because it must admit it was a coherent explanation of his thinking, in 2012 and 2013. If we go to the judgment in H3 at 314, this is H3 at 314, tab 10A. What the tribunal has to do in the light of this evidence is to weigh up all the facts. It weighs up the price, the alleged value transfer, but it also weighs up Mr. Baton's evidence on volume.
Where are you reading from now?
I'm not, but it's page 314 of H3.
Sorry, paragraph.
Well, it's
Internal page number?
Internal page number, it's 14. 14. It's paragraph 19 to subparagraph.
It's paragraph 19.
No, it's paragraph 19, subparagraph 11, and then subparagraph 12. It's on page 314 of page 3, page 14, internal of the judgment.
Paragraph 19 is almost as long as the President's cross-examination.
It's quite tricky. But in subparagraph 11 and 12, what the tribunal is doing here is saying, look, we have got to weigh up. We're being asked to make an inference from the facts. We have said that the value transfer is a weighty piece of evidence. It's a strong one. And that's what the tribunal says at 11. We consider that the inference of the existence of a collateral out of the value to be a strong one. But it needs to be explained. And this is what happens in H3. It needs to be explained. In these circumstances, the CMA, we consider, was obliged to put the existence of the collateral understanding. And then in 2, the tribunal says that Mr. Baton, in response to questions put neutrally to him by the tribunal, articulated reasons for the arrangement between AMCO and Auden from the perspective of AMCO. So he's referring there, the tribunal's referring to there, to articulated reasons. We then go to, excuse me, page 379, where we saw this yesterday, but it is very important. So page 379, 79 of H3, this is paragraph 121, and it's subparagraph 2 Roman 5, and then subparagraph 3 and 4. So this is at page 379. Mr. Baton's answer was the arrangement suggested by the CMA was entirely irrational on the part of AMCO.
Sorry, you're going to have to give me the paragraph again.
Sorry,
something?
it's paragraph 121.
121. Okay, thank you.
Subparagraph 2, little Roman 5. And there we see the tribunal referring to the evidence, essentially, the 50% point and the 10 to 15% discount. And then over the page on 380 of subparagraph 3, the tribunal's questions enabled Mr. Baton to put AMCO's position with considerable clarity. If AMCO's position was right, there could be no collateral understanding of the sort alleged by the CMA. There is thus, on the record, an articulated, reasoned denial by the witness of the collateral understanding.
What?
Yeah.
You've taken us to 2 passages in this judgment which seem to me to be completely inconsistent with each other. Because how could Mr. Baton have said a great deal about the irrationality of the collateral understanding? Which is entirely correct. He did say a lot about that in his evidence. If, as the tribunal had said earlier in this judgment, Mr. Dumitru had not cross-examined him about the existence of the collateral understanding. That's what they say in paragraph 12.
Yeah, it is, what is proving the collateral understanding? And the CMA relied to prove the collateral. What is the collateral understanding? It is a pay for delay.
That's not answering the question. At paragraph 12, Roman 1, the CMA has never suggested this as a reason for not cross-examining on the existence of the collateral understanding. So what the President, or Cat, is saying there is you didn't cross-examine, or they didn't cross-examine about the existence of a collateral understanding. Here we have Mr. Bacon giving a whole load of evidence about denying it, saying why it wasn't true.
Yes,
And the reason for that is because he was cross-examined about the existence of the collateral understanding.
But these aren't, as we saw in Phipson 1212 and TUI, he's giving an explanation.
Well, he's giving an explanation, and then the tribunal has to decide whether it accepts that evidence or not. In its first judgment, HC2, it doesn't accept that explanation.
Well, it does actually in H2, at paragraph 71, from memory, but the tribunal doesn't take it very much further.
No, what he says is we accept this as evidence of an accurate description of how the market works.
Yes. And then what?
That was the general evidence that might disagree.
And so what Mr. Baton is, to be fair to Mr. Baton, what he's doing is that this is how the market works, and this is how we would have operated in this market. And at paragraph 145, and then I'll just quickly go to the documents and then sit down. Paragraph 145 of H3.
Yeah.
That's page 391. This is where I'll just pick it up at 2 and 3 and 4. The appeals did not just put the inference of an existence of unlawful collateral in issue. So we're talking about an inference of the existence of the unlawful collateral understanding. The appeals put forward a positive case from witnesses who had relevant evidence to give, who said at 3, those assertions were not so inherently implausible as to be dismissed without examination. And then we rely on this. So, to the contrary, Mr. Baton's version of events, namely it would have been in AMCO's interest to enter the market the moment it could, and that the second written agreement was no more than a stopgap, enabling AMCO to supply the market whilst they secured their own independent supply, is a coherent explanation of AMCO's conduct, which is inconsistent with the existence of the collateral understanding on which the Hydrocortisone decision rests. Without cross-examination of this version of events, neither the CMA nor the tribunal can properly disbelieve them and hold against the appellants. And the tribunal has held that Mr. Baton's explanation of what Advance would have done as a first generic into the market was coherent. The tribunal does not believe it was sufficiently challenged. So the economics of the first entrant was not sufficiently challenged, and therefore the tribunal is not prepared to infer the pay for delay. It is a straightforward question of an arbiter of fact weighing up evidence, weighing up the value transfer, weighing up how the market operates with the first generic, weighing up his evidence that this is what Advance would have done, and then saying, well, we don't think it's sufficiently challenged, we're not going to make the inference that the CMA does. And the 50% point is as simple as that. And can I just lastly go to the documents, and then I do need to sit down, because the documents do support his explanation, and it's very important that the court sees this. So could I go lastly then to the unagreed supplementary bundle? This is Vol 3. Because we don't see this contemporaneous evidence in really H2 or H3, and it is important that the court is aware that Advance produced a lot of emails to support his explanation. So this is volume 3 of the unagreed supplemental bundle. Sorry, listen, I beg your pardon. It's volume 2. I'm so sorry. I'm so sorry. Volume 2.
Any idea of page?
It's page 1657. No, it's not. No, it's. I did have the right one. Sorry. I beg your pardon.
Well, you find the document you want to refer us to, and then we'll look for it in these bundles.
Yes, I do. What's going on? I just the tabs are all. Oh. Yeah. Yeah. So it is volume 2. I do apologise. It's tab 22. Tab 22. It's page 1657. 1657.
Kelly Lifton.
This is Kelly Lifton. So all I want to do is draw the court's attention to several documents which show Advance's desire to be the first generic to market. And the relevant bit is at the bottom. Hi Kelly, this is from AMCO. And this is dated the 20th of December 2012. Hi Kelly, it was agreed at last week's project support group meeting to manufacture a 10 mg hydrocortisone batch as quickly as possible. Now that is not evidence of delaying any product. That is evidence consistent with the Deloitte report that we saw yesterday that Advance wanted to get on with this as quickly as possible. And there were many other emails that show that. And Mr. O'Donoghue will look at the ASICA. And we set them all out in Annex 1 of our closing submissions. We go to tab 24. It's another AMCO Kelly Lifton email. This is at 1662. This is where AMCO Advance is chasing ASICA. We see this. This is any news on meeting on these. This is hydrocortisone. So again, Advance is saying to ASICA, what's the news on this? And again, this is just a snapshot of the narrative.
Sorry, the dates of these. This is January 2013.
This is, yes, so the first one was 20th of December 12. This is 30th of January 2013. 30th
December 2012.
31st of January 2013.
Yeah.
Any news on the meeting on these is high. Things are starting to become a little fraught at this end. We need to place orders. So again, this is just a snapshot of the narrative that we gave to the tribunal. Then, can I go to tab 26, which is 1664. Again, this is in support of Mr. Baton and whether he's given any sort of nod and a wink. This is the 27th of June 2013. It is, just to put this in context, it is obviously, there's many recipients of this, but this is in the context of a potential investor into AMCO. What Mr. Baton does, and the reason I'm referring to this, is we see in the middle of the page him referring to the Deloitte diligence report. So that is the Deloitte report that we saw from October 2012. And he's forwarding this Deloitte diligence report to many other persons. And we saw the terms of that, which was that AMCO wanted to get into the market early. So he is still of the view, he's forwarding that report, consistent with his evidence in his witness statement, that he wanted to get on with this. Just a few more. Tab 27, page 1670. This is from Jane Hill to Brian McEwen, who we've heard about, copied to the General Counsel, Robert Sully, copied to, this is not confidential, copied to Lucinda Turner, who actually signed the second written agreement. Hi Brian, where are we up to with the agreements with Ord & Mackenzie? I believe we may be getting our own stock from ASICA in 14th February, so would then terminate the agreement with Ord. So there is at this stage a contemporaneous document about terminating the supply with Ord and going it alone. We then have tab 28. We can pick this up at 1672. This is, I just referred to this at the top, this is Lucinda Turner. She's the Director of Supplies, and she's asking Jane Hill, who's the Commercial Director, are we going to compete with Ord & Mackenzie? The response from the Commercial Director at 1671, from Jane Hill to Lucinda Turner, copied to the General Counsel, yes, there will be two of us in the market. You then have, in the middle, Mr. Sully saying, can we meet and discuss this? I'm not clear on the strategy. Having heard numerous different views recently, I'm back tomorrow afternoon. Until then, can we please put this on hold? I'm concerned that we are spreading confusion. Mr. Baton at the top says we can, Rob, so we can. It is clear to me, but let's chat then and have a meeting if we need to. But so he's saying the strategy is clear to me, but let's chat and have a meeting. What then happens? We go at 1679 on page on tab 29. Tab 29, 1679. So this is all towards the end of 2013. At the bottom, from Brian McEwen, Rob. This is to Rob Sully, the General Counsel. Just spoken with Nikki. She was on the technical side. Her objective for this meeting was just for me to give her and whoever some background specifically with reference to our potentially launching the AMCO product. Mr. Sully says, Brian, okay, fine by me. I am just concerned there is confusion about our strategy here. I think it's pretty simple, which is that we source from Ord for the time being, while we work out if we have fully compliant supply from ASICA, and also while we investigate the orphan status of the Ord product and what it would take to get Adrenal onto our license. And then we get a response from Mr. Baton. I agree with your summary, Rob, though just to add, we should, as fast as we can, to have a saleable product of our own from ASICA. So Mr. Baton is still of the view that as fast as they can, they have a saleable product from ASICA. I mentioned yesterday, I've got two more documents when I sit down. I mentioned there was a document beginning. We go to tab 31. Tab 31 at 1695. 1695. This is from, in the middle, John Baton, 2nd of January 14, to copy to Robert Sully, to another director, Guy Clark. This is in the context of Ord asking Advance AMCO to buy its business. Mr. Baton says, we aren't thinking of buying it. I think this is a big risk for us, and if I were him, I would tell us to and stop supplying us. I really wish that we could find a way to put our own product on the market even without the indication. Now, again, these are contemporaneous emails, and in my respectful submission, that does not reflect any nod or a wink, any common understanding between Mr. Bayton and Mr. Patel or Auden. He can't understand Auden's logic. Indeed, he says he should tell him to get lost. And then the last document that or there's two more actually. The next document is at tab 38. This is the minutes of the meeting of the page 1727. So many directors here. We see the General Counsel, Mr. Sully, is in attendance. We see Mr. Bayton there. And if we go to page 1729, this is to the whole board. Mr. Bayton confirmed that negotiations with Auden Mackenzie to agree formal written contracts for the supply of hydrocortisone had proved difficult, and that signed contracts had still not been achieved. However, Mr. Bayton was hopeful that contracts would soon be signed. It was noted that, as a result of a more positive outlook on the group's own hydrocortisone product that is being developed by AZICA or Andifarm, it was hoped that the group would be able to obtain its own fully compliant product in the next 4 months, and thereby move away from sourcing hydrocortisones from Auden under the legacy arrangements that had been inherited from the merger with Andifarm. Mr. Bayton explained that the issue with the development was that Auden had obtained orphan drug status for their product in relation to the adrenal insufficiency indication, which Amil and ANCO were currently investigating. It was currently thought that Amil's own version would be able to compete with the Auden product, even if it does not have this indication, but investigations continue as this is a 3 million EBITDA market and there is much to stake. The last document that if we go to volume 3, is that the uncontested evidence is, and this is at tab 44, page 1755. So we do know that Advance terminated the supply arrangements with Auden, and they were going to go it alone, as per what has been decided at that board meeting. What then happens is we have Auden implementing what I described yesterday as Project Guardian. And there was lots of evidence on Project Guardian.
Project what? Project
Guardian.
Guardian.
As I said yesterday, as the name implies, it's not a market sharing agreement. It is disparaging what is perceived by Auden to be a product that's going to compete with it. And this is a draft letter to all the pharmacies, and this is basically what did a lot of the damage to AMCO's business. That's what gave rise to the factual situation in June 2014. But we see here that Auden is saying, dear whoever it is, it would be dear Boots, it would be dear Lloyds, as the manufacturer of the only currently available UK licensed hydrocortisone 10 mg, Auden Mackenzie are contacting clinicians and patient support to draw attention to an important issue. It says they've got the marketing authorization for the adults version. Recently, another manufacturer has been granted a license by the MHRA for its formulation. We wanted to ensure you that we are aware of the potential for confusion that may arise. It's not licensed essentially for use in adults. And you see at the footnote that the person that Auden believes is coming onto the market is AMCO. And I finish with making this obvious connection. We have seen in the Board of Directors meeting, AMCO being of the view that it is going to enter the market. That is AMCO's state of mind. And we have seen from this draft letter that went to all the pharmacies what Auden's state of mind is, which is it believes that AMCO is going to come onto the market. And where, I would ask rhetorically, where on earth is the nod and a wink, any sort of meeting of minds that this evidence gives rise to? And with that thought, unless there's any further, I will come back for a cameo role on object or whatever, but that's all I have to say.
Thank you, Mr. Brealey. Mr. O'Donoghue.
My Lords, I will deal with three of the issues on the list of issues, 1A and 1B, which go hand in glove, secondly 1C, and then finally 4B, which is part of the respondent's appeal against H2. And in terms of coverage, most of my time will be taken up with issues 1A and 1B. I can be quite brief on the other 2 points. And I will deal with 4 of the 7 documents Mr. Turner took you to on Wednesday, and Ms. Ford will deal with 3. The only other preliminary point I should make, Mr. Brealey gave you a list of things which he says were not put and not properly challenged. For the avoidance of doubt, I have things I wish to add to that list, and I understand Ms. Ford likewise has things that she wants to add to that list. So the list, from our respectful perspective, is not yet closed.
Well, can that list not be put in one page of a sheet of paper so that we don't have to write it down in different and no doubt inaccurate ways?
Well, that seems to me a very good idea.
This case turns on what you say was not put to the witness, and you're now all disagreeing about what the list comprises. I would like a single list. Mr. Brealey says this. I wrote it down yesterday. Mr. O'Donoghue says this. Ms. Ford says this. Mr. Giles says this. And then I can put that, we can put that in a judgment and understand correctly your case. Because I find, personally, the hundreds of pages of skeleton argument incredibly indigestible. And I'm not sure that I've heard yet the same things I read in the skeleton argument coming out of submissions. So I want to understand your case as clearly as possible.
Yes.
And 1 page rather than 100 pages will help me.
Well, we will do that.
Thank you.
Seems to be an excellent idea. So well, starting with issues 1A and 1B.
Yes.
Can I just give you the essence of the point and then develop it? Before I get into the weeds of trenches, can I make clear what I'm not saying? I'm not saying that a Chapter 1 agreement cannot be inferred. The nod and the wink point. It can, of course, be unwritten. I'm not saying that a Chapter 1 agreement needs to be a contract or indeed to have formality. And I'm not saying that anything turns on the label collateral or side agreement. I quite agree with the Chancellor. We need to focus on substance and not on labels. So we could put all of those straw men to bed. The essence of my point under 1A and 1B can be stated very shortly. The decision finds that the written agreements are not themselves in isolation an object infringement. Mr. Turner denied that on Wednesday. He is wrong to do so, and I will show you why. It therefore follows from that finding or concession that for the CMA to succeed, it needs to show some different and broader understanding that is not coterminous with the written agreements, and of course that amounts to an object infringement. Now, as it happens, that is what the CAT referred to as the collateral or side agreement as a shorthand, But again, I'm not getting hung up on the label. I want to focus on the substance of the point. And the basic point is the CMA necessarily, given the concession, had to allege something that went above and beyond the written agreement. What that something else is not explained in the decision. In the proceedings below, Sinven and a number of other of the then appellants had grounds of appeal saying that there was a fundamental lack of clarity on the CMA's case on the infringing agreement. And I will take you through various attempts by the CMA to explain what its case is in ways that we say are unsatisfactory. The CAT in H3 found...
Sorry to stop you so early. Can I just be very clear as to what you're saying about the decision? Are you saying that the decision positively found that the supply agreement was lawful, or that it just simply didn't address the legality or otherwise of that agreement because its view was broader?
I'll show your lordship in 1 minute. But
So your position is they positively found that it wasn't
they find
lawful.
that the written agreements in isolation are not an object agreement. The CAT in H3 found that the CMA was not clear on its case on the difference between the written agreements and the offending 10 milligram agreement, and I will show you where they found that. We say they were quite right to do so. The upshot of this, we say, is that the CMA has failed in the basic task in a quasi-criminal context involving 9-figure penalties of identifying what is the offending agreement, since it cannot coherently distinguish that from the terms of the written agreements that it accepts are not in themselves an object infringement. Now, we say if that is correct, it is the end of the matter. The decision is simply incoherent as a result, even before one gets to the question of cross-examination and fairness. But we do say, and this is my final point in terms of foreshadowing, that the CAT was also right to consider that this failure on the CMA's part raised fairness concerns. The CAT expected that the essence of the collateral agreement, that was not the written agreements, would be put to the AMCO witnesses. It was not, because the CMA never explained what that essence is. And at the risk of stating the blinding obvious, you cannot fairly put something in cross-examination that you cannot coherently distinguish or explain to begin with. So those are the headline points. Now, just to develop those, can I start with what was and is the CMA's case? This is an unusual administrative proceeding which had no less than 3 statements of objections. And as I will show your lordships, there was an important series of vote, pass, and concessions made by the CMA in the context of those administrative proceedings. Now, I want to run through very briefly the vote, pass, and the concessions, because in my submission, those concessions and changes, they are fundamental to understanding what went wrong in this case. Can I start with the first statement of objections back in the heady days of March 2017? This is in the unagreed bundle. It's tab 73, volume 3. And it starts on page 2042, paragraph 4.104. This is the CMA's statement of objections, effectively a draft decision.
Sorry, unagreed bundle volume 3.
3, my lord.
Tab
73. Page 2042, and it's 4.104. Your lordships have that. It's, in my version, highlighted in the green that doesn't make it entirely easy to read. There we are. So at 4.104, they say the 2 written agreements constituted the faithful expression of the parties' intention to conduct themselves in the market as described below, each of the agreements, therefore, forms an agreement within the meaning of Chapter 1. So they define the supply agreements. And then over the page of 4.105, the CMA provisionally finds that the supply agreements, as defined in 104, have the object of restricting competition by incentivizing AMCO not to enter the market independently and to instead share a fixed proportion of Actavis's share of the market, and so on. And then just to round this off, at 4.109 at the bottom, CMA visually finds the value transfers financially disincentivized AMCO to independently enter the market for hydrocortisone tablets in the UK. So at this stage, what is being said is the written agreements are the object agreement, and the gravamen was that they financially incentivized AMCO not to do its own thing. It was an incentives case at this stage. Now, as indicated, there were two further statement objections. We can pick up the administrative chronology in the decision, which is in the first core bundle. At tab 11, there was a helpful summary at the start of the decision.
So where are we going to? Which decision?
The core bundle, my lord.
Which
The
decision?
CMA decision.
The
CMA hydrocortisone decision.
Yeah, thank you. Which page?
My lord, it starts at 523. 523, my lord. And
523, thank you.
And it's 2.9. You'll see that there's a reference back to the SO we just saw. In March 2017, they provisionally found the supply agreements were an object. And you see a reference to fentanyl. And I'd ask you to underline the first sentence of 2.9. The supply agreements in themselves had an object restrictive of competition. So that's the position then hitherto. Then at 2.11, you'll see, notwithstanding SO1, CMA continued to have reasonable grounds to suspect there was a traditional market exclusion agreement. So at this stage, the CMA is making two observations. One, it is nailing its colours to the mast that there was a non-traditional object agreement, and it's also saying we think there might be a traditional object agreement as well. We then go over the page at 2.17. You'll see a reference to the second statement of objections. And you will see, if your lordships completely look at that. So at this stage, which is in February 2019, the CMA is hedging its bets. It's saying we have a primary case of what they call a traditional market exclusion agreement and an alternative case based on a non-traditional.
Where are you reading from?
My lord, it's 2.17 on page 525. You'd see CMA, second line, CMA originally found in the next sentence in the alternative. So there's a primary case and an alternative case. And again, the penultimate sentence, I'd ask you to underline, in themselves amount to restrictions by object. So at that stage, they were sticking to their guns. The written stuff was object and had an alternative case that there was a traditional market exclusion agreement. And then finally, if we go over the page to 226, we see the third effective draft decision, the third statement of objections. Then, my lords, if we jump down to 227C, adjusting the legal characterisation of the agreements, the CMA no longer found that the supply agreements themselves amounted to an object. The CMA provisionally found that the evidence set out in the SSO amounted to a clear traditional market exclusion agreement, and so on. So they had jettisoned the non-traditional or novel case based on incentives. The written agreements were an object. Their case now is what they called a traditional market exclusion agreement. So the SO1 theory of harm had been jettisoned completely at this stage. Now, I should also make clear there is no other finding that the written agreements restrict competition.
Can I come back to my original question? Do you construe the decision as giving a clean bill of health to the supply agreement, or are they simply saying that's no longer the focus of our attention? There's two nodding. There's nodding and then there's nodding. Nodding for the first proposition on this side of the courtroom and vigorous nodding for the second on the other. But the words in context, they start by saying supply agreement's an object restriction. They then execute warrants, they get further information, they modify their case, and then they say, in and of itself, it's not the focus of our attention, it's that plus.
Yes.
Does that amount to a clean bill of health for the supply agreement? Or is it just simply a shift in the focus of a case?
Well, what they are saying in our submission loud and clear, 227C and also 6.899, is that if the only agreement is the written contracts in themselves and nothing else, that is not an object. In my respectful submission, there is no other sensible way to read 2.27C. Because if one looks at the chronology, they started off in SO1 saying, we think the written agreements based on incentives are themselves infringing. And you see in 227C, that has been binned.
So this is quite fundamental to your case, because there's a different analysis. If they're saying a supply agreement is absolutely all right, no object agreement, therefore the only thing that renders it unlawful is the plus. That's one analysis.
Yes.
The other analysis is it's the starting point of the total unlawful arrangement. It's a constituent part of it. We're not going to focus on that alone.
Yes.
But that plus other things constitutes the single arrangement that we're looking at.
Well, yes.
There's a subtle but quite important difference
Yeah,
between the
well, I'm going to go on and develop this, obviously, in more detail. But our submission is yes, that the fork in the road is they have to show, and they say this in defense of paragraph 48, which I will show you, they have to show, and I'm using their own words, something different and broader to the written agreements.
Otherwise,
That is common ground.
The default is legality. They say, otherwise, the default is not legality. It's just, I mean, at the end of the day, their infringement is something broader than the supply arrangement, and that's your target.
Yes.
The analysis is slightly different.
Well, if I say so, it's a very good way of putting it. It is common ground, we say, they need to show something more than the written stuff. To put it another way, if all that is being done is implementing the written stuff, implementing
But you're
a
entitled
written
to say on their analysis, whether they're saying it's lawful or not.
Yes.
On their own analysis, their Aunt Sally, for you to knock down, is the supply agreement plus.
Well, absolutely. So that is why I don't want to get hung up on not unlawful, lawful, and unlawful.
Yes.
This semantic debate in my submission is sterile.
Yeah.
The practical, substantive point, there needs to be something else.
Yes.
And of course, sotto voce, it needs to be an object infringement. That's the critical.
Yeah. Okay.
But I'll go on to develop this, but this is important. So we
Well,
say
that's
this.
what 227C says, really, doesn't it?
Well, indeed.
Because it starts off by saying that they weren't saying that the supply agreements were in themselves amounted to restrictions of competition, but they end up saying that they were a sham because they weren't the full picture.
Indeed. And but your lordship's right. The combination of the words "no longer" and the sham, there has to be something else. And of course, as I'll show you,
the critical point.
That's the critical point. And
The broader understanding on how you define
yes,
it.
yes, yes. Now, quickly to look at the defence, because it is a pleading, we're entitled to rely on it. This is in supplemental volume 3. It's my 1107.
Which page? 1107.
CMA Defence, supplemental volume 3, 1094. And, my Lord, your Lordships have paragraph 48. We saw this yesterday, Mr. Brealey. We did. So first of all, part of the bargain not recorded in the written agreements, that's the Chancellor's point. And then at 1118, paragraph 88, they say, and you'll see the bit underlined, paragraph 88, my lords. They underline.
Sorry, I haven't got this at all. 1188 is something.
Treble 18, my lord.
Sorry?
Treble 18.
Treble 18.
And which paragraph are you looking at?
My lord, it's paragraph 88.
Yeah, it's 1105 in the printed
Oh,
version.
this is the Duff bundle.
1108. You're
Forgive me,
thinking
my lord.
too many ones then. 1108.
And your lordships will see different and broader underlined. So that is why I say it is actually common ground. There needs to be something else that is not in the written stuff. Now, your lordships will see the IE part. I'll come back to that in a minute. So there is an attempt at least to explain what the something else is. I'll come back to that momentarily. Can we then quickly look at H2 and 3 to see where these concessions or common understandings are recorded by the CAT? If we can go back to the core bundle, starting with H2, please. So it's 10B, page 411. Paragraph 12(3). So they record our submission. The written agreements are the alpha and omega from the appellant's perspective. And then, since as the CMA has accepted the agreements as they stand do not infringe competition law, it was a necessary part of the Hydrocortisone decision that those agreements were not what they appeared to be. So that is, my lord, the Chancellor's point. And then at paragraph 13, self-evidently, the CMA cannot successfully defend the decision by reference only to the terms of the first and second written agreements. The CMA has found that these agreements did not infringe the Chapter 1 prohibition. Now, I should note there parenthetically, of course, there is no subsidiary case that the written agreements are restricted by effect, and there is no abuse of dominance case that it was an abuse by order of its dominant position to enter into the written agreements. So the only case which was jettisoned was the object case. Then quickly, if we can go to H3 and 10A. Just quickly with the references, it started in 1904, page 311. The decision did not find, and CMA never
Sorry,
contested.
paragraph, please.
My lord, it's in 369, 19 subparagraph 4.
Sorry, 19 paragraph.
Subparagraph 4. Decision did not find, and the CMA never contended that these written forms of agreements in themselves infringe Chapter 1. And again, you see the point about the incomplete statement. And then 23, a couple of pages on, page 376, third sentence, the CMA did not contend these written forms of agreement themselves infringed Chapter 1. 43.2, page 394, the existence of a collateral understanding in addition to the first and second written agreements was the single most important factual question in relation to the cartel infringements. CMA accepted, as it had to, given the finding in the decision, that in and of themselves, the first and second agreements did not infringe competition law. And I'll give you the rest of the references. There's a risk of this becoming boring and clerical. It's 49.1, little 2, 52.1, 82.2, and these are all in H3. Now, remarkably, in these proceedings to date, you have not been shown the contracts themselves. So can we please look at those? They're in volume 6 of the supplemental bundle. It's in tab 27, and it's 240. Well, it starts at 2404. So this is the second written.
2414.
2404.
No.
Well, supplemental 6, tab 27.
No,
It's 2395 in the Duff reference.
no, it's not on tab.
2413 in ours. Could be anything, frankly.
It's like bundle roulette.
So is this the agreement of the...
This is
And
the
that's
second
the
written agreement.
This
of
is
the
the second written agreement.
25th of June 2014.
It's at
2391.
tab 26, 2391.
Yeah.
Thank you, my lord. Even the tabs are wrong. So, Rose, the bit I want to focus on, clause 2.2, is on internal page 5 of 22. It says, Amity Farm shall procure all of its requirements in the territory for hydrocortisone in tablet and capsule form on an exclusive basis and shall not directly or indirectly distribute, sell, supply or sell in the territory any other hydrocortisone products in tablet or capsule form. And then there's a caveat. However, for the avoidance of doubt, nothing agreement prevents AMCO applying for an MA at any time, and so on. And secondly, entering the market, provided it gives 3 months written notice of its intention to do so. So there is a non-compete clause subject to a unilateral contractual right on AMCO's part to enter the market, giving 3 months notice. And for your Lordship's reference, if one looks at clause 1, you see the effective date, and then there are definitions, various definitions in there. And I'll ask your Lordships to look at the definition of product, which is the Auden 10 milligram product. Then finally, my Lords, at 17.2, it's on internal page 18, there's a termination clause. And if AMCO notifies Auden of its intention to enter into clause 2.2, the 3 months, there'll be an option to terminate on Auden's part. And finally, I'd ask you to note on internal page 21 the agreement is signed by Ms. Turner, who is a director of AMCO. And finally, at 22, there is an entire agreement clause. So there is no doubt this was a genuine contract signed at the highest levels within AMCO. The first written agreement, which I don't need to spend too much time on, is in the previous tab. It is essentially the same as the second. It has a non-compete. It preserves the right of entry. The primary difference really is that there is no requirement, unlike clause 2.2, to give 3 months' notice of intention to enter. The right to enter is carved out as a unilateral right without having to give any particular notice period on AMCO's part.
What page is the first written agreement?
Well, in my bundle, it's in tab 25, and it starts at 2378.
Tab 24, 236.
Thank you, Mark. So we have two contracts with non-compete clauses, both preserving AMCO's unilateral contractual right to enter, both signed by directors, and so on. Now, one of the CMA's points, of course, is that competition law recognises that cartellists may not turn their mind to every fine detail of the arrangement, such as duration. And that's obviously correct. But in this case, they did, in the written contracts. We ask, what relevance does the CMA's point have? For the CMA's case to work, you would need to say what is written down in the contracts is not the agreement, and there is something different and broader that amounts to an object agreement. Or to put it another way, performing an agreement that is not anti-competitive is not anti-competitive. Now, this is a vitally important point, as Mr. Breedy submitted yesterday, and I'll show you this shortly. The one thing that came out loud and clear in the evidence in chief from Mr. Baton and Mr. Sully was there was nothing going beyond the terms of the written contract at any stage. So the battle lines were very firmly drawn on this fundamental point. Now, we've seen the contracts, so the next issue is, what is it the CMA alleges is the thing that goes above and beyond these contracts? Now, in my submission, we don't need to dwell too much on the decision on this point, because it is eloquent in its silence, in not explaining what the something else is. When Mr. Turner addressed the point on Wednesday, he gave you a single reference at 6.899. Let's quickly look at that. It's in the second core volume, 1168. It's paragraph 6889.
Sorry, 689.
6.899.
Yeah.
And what is 1168, internal page 811. And the bit he focused on, the first sentence, it is not the supply agreements in themselves that the CMA has found restrict competition, and so on. And the last part of the sentence is important. They include the commitments, the commitment not to enter the market. Now, in my respective submission, that doesn't assist the CMA one jot. It reiterates the point of 227C that the written agreements in themselves are not object infringements, and it certainly does not in any way explain what is different and broader compared to the written agreements. I mean, they say in plain terms, oh, well, it's the agreement not to enter. But both clauses in the written contracts have non-compete agreements. So that is not a different and broader thing. That is exactly the same thing on its face.
It's not the same thing. I mean, it's just not. It's either a commitment not to enter, full stop, or there's the 2.2 and 17.2 in the agreement, which is hedged around with different commitments.
So far as the 10 milligram agreement is concerned, paragraphs 6, 17 and 680 on pages 916 and 917. Sorry, yeah, 916 and 917 of the paper one. I imagine it's 919 and 920. My math's right. But they say in very clear terms what the common understanding was. Orton would supply first Waymaid and then Amco with 10 milligram hydrocortisone tablets on terms that amounted to monthly payments or value transfers to them, and in exchange for those payments, each of Waymaid and Amco would not enter the market independently with its own 10 milligram hydrocortisone tablets.
Well, your Lordship is quite right.
Well, that's exactly what the common understanding was stated by the CMA to be.
Well, that's quite right. But all of that is in the contract.
Well, it's what?
All of that is in the contract. Again, the contracts.
No, it's
Let's take the second written
As
agreement.
my lord just puts you, it's not.
Well, what is in the contract, and we see this in clause 2.2, is a non-compete clause that AMCO will only supply the
Subject to an entitlement to come onto the market
Indeed.
3 months' notice. But
Indeed.
what the CMA is alleging, and everybody knows this, I don't know why there's so much shadow boxing going on, frankly. The CMA's case was that wasn't the true position. The true position was that an undertaking, in return for getting this stuff at £1 a pack, when it was worth, if sold to a third party, about £35 a pack, your clients would undertake not to come onto the market.
Yes, your Lordship's quite right. And the consequence of that is that, in fact, what was written down, that there was a non-compete of up to 2 years' duration and a unilateral contractual right vested in AMCO to enter on notice, that they were a sham. In other words, what was written down is not the agreement. So, my Lord, that is very helpful when I say so, because it draws the battle lines in a very stark way. I now want to move on to how this distinction was explained by the CMA in various iterations and put to the tribunal. And my submission in a nutshell would be, by the time one gets to the post-H2 period culminating in the H3 judgment, the tribunal is utterly baffled as to what is the CMA's case on the difference, and in particular, in what meaningful way is it different and broader than contracts. So that is the crux of this. And I will very, very briskly take the tribunal, or take the court through this.
What are you taking us through?
There have been a small handful of attempts by the CMA to essentially grasp the nettle identified by the Chancellor. I think it is important to look at how they're putting their case at successive stages. I'm then going to show you what happened following H3, culminating in the judgment, and show where this point on the lack of distinction between the written stuff and the unwritten stuff comes home to roost.
Does it really matter whether one calls it a sham or an inconsistent agreement or a consistent agreement? You have a supply arrangement with a right to enter subject to notice. You could have something which call it collateral, it's not necessarily inconsistent, an understanding about how that option is to be exercised. In other words, it won't, provided the favourable terms of the deal are continued with. And then the CMA simply say, all right, you've got two parts to this arrangement. Part one, all right, we're not challenging that as per se unlawful, but when looked at in the way in which that option was exercised and the financial payments, financial incentives passing from one to the other, it was never going to be exercised, or at least de facto there was a huge disincentive to exercise it. So,
well, I'll come to this.
But isn't that really, it's that latter bit which you are saying wasn't cross-examined properly about?
Yes, well,
Isn't that the essence?
It's part of it, my lord.
Right.
So I'm saying a number of things. I do need to develop this quite carefully because it's important to be precise. The fact that the incentives theory based on the written agreements has been jettisoned, that is a very important concession, because in my submission, what the CMA cannot do is then recycle that point now.
So the concession is that
In the first statement of objections, that the incentivization that the written agreements gave rise to, you will recall, my lord, they originally said, oh, well, this is an object in itself.
yeah.
That has then been jettisoned. So they cannot recycle that theory of harm now. That ship has
I
sailed.
don't think they have or are trying to, are they? They're basically
Well,
saying it's the totality.
There are shades of it, if I can put it that way.
Okay.
I don't think so. I mean,
And-
their case has always, certainly before this court, and I think before the CAT, there's always been, as set out in paragraphs 16, 17 and 18 of the decision.
Well,
There are two sides to it. In return for getting this stuff at a knockdown price, you won't come onto the market.
yes, well, if I don't need to worry about that, then
I mean,
happy
they can
days.
respond to it in
But my lord, if I may say so, the point you've made hits the nail on the head, which is, for the CMA's case to be coherent, they do need to say two things. First of all, when we see the 2-year non-compete in the second written contract, in fact, it was something longer, for example. It was different and broader. And in my submission, they also need to say, when this unilateral contractual right vested in AMCO to enter with 3 months' notice is set out in the clause 2.2, in fact, what was agreed was that that would never be exercised. So there was effectively a rider to that, or something which is
de facto.
effectively kills that.
Yeah.
And in my submission, if what is set out in writing in isolation is not an object, they need to tackle something different and broader, certainly across those two parameters. And they kind of go both ways. I mean, either the written agreements are the agreements and there's no dishonesty, or there is something different and broader to the written agreements. But if that's true, there must on some level be dishonesty.
I don't get that at all. I completely fail to understand what any of this has got to do with dishonesty. This is about whether there was a nod and a wink which said we're not actually going to enter a market. It is as simple as that. You can intellectualize it, you can complex it, make it more difficult. It's not difficult. It's a simple case. That was the case being put against you. It's still the case being put against you. It was not saying it's crooked. It was saying you entered into agreement and you actually agreed not to enter the market. Full stop. That's why they paid you so much money. Now, why can't we just address the real question? Was that case put or not?
Well, my lord, I'm coming to that. The reason for laying this ground, it's very, very important. If, let's take the second written agreement. If, in isolation, a 2-year non-compete clause is not an object agreement, let's put it in those stark terms. Auden and AMCO could agree to a 2-year non-compete expressly and in writing up to 2 years.
I'm not certain I read the decision that way. I read the CMA as essentially being agnostic as to that. They haven't, as it were, given you a negative clearance or a declaratory ruling that it's clear. They're just simply saying it's not our target. On the facts, following the execution of the warrants, they got additional information and the case developed.
That was the whole point, that they exercised the warrants, which I'd forgotten that were actually the subject of the Concordia decision, because that was the earlier name for, I think, for AMCO. And they got more information on the execution of the warrants, which was the basis for their for this broader and different understanding. But none of that involves, as my Lord Master of the Rolls put you a moment ago, none of that involves having to prove dishonesty or anything of that kind.
Well, I've given you the reference to the decision of the defence. I'm not going to go back down that rabbit hole. What I'm saying, I mean, focus on the expression different and broader in their defence. If all that is alleged is you have a non-compete of up to 2 years and a unilateral right in AMCO to enter, for the CMA, and that is not an object, that is my case, for the CMA to get any traction on a different and broader understanding, they need to say, in my submission, one of two things. They need to say, AMCO and Orden agreed in a Chapter 1 sense that, contrary to what is set out in Clause 2.2, AMCO would never enter, or at least would not enter for some different period. And in my submission, they also need to say, given what is set out in writing, that there is a non-compete which is broader than Clause 2.2.
But that's the same way of putting the first point. If there's a payment and they are agreeing in a concerted de facto sort of way not to enter the market, that's simply no narrower or broader than the existing clause, because that's open-ended. I mean, that is, I must say I rather share the view of the Master of Rolls. That's what this case turns on.
Yes.
Was there something over and above the supply agreement?
Indeed.
Was the case put fairly to the witness?
Yes.
And whatever one thinks of the way in which the question of dishonesty arose in the judgments, in a sense, by the time you get to H3, it sort of almost disappears off the arena, and the issue becomes slightly different. That, for good or for bad, that's what it ultimately ends up with. Was the case put on what we're all calling the collateral understanding?
Yes.
That which was over and above the supply agreement.
The written stuff. Yes.
Now, the decision, the paragraph you referred to at 6899 cross-refers back to where the CMA have set out this broader case. Now, obviously you disagree with it on the evidence and so on, but the procedurally, isn't the essence of this, was it put in a fair way?
Well, in essence, yes. Now, in my submission, what needed to be done, say, well, look, and I'll come to this, say, well, look, hang on, Baton. Let's look at the contract. Let's look at Clause 2.2. I'm putting to you, Baton, contrary to what you say in your evidence in chief, which I will show you, that this was not the full extent of the agreement. There is something else, and Mr. Baton, here is the something else, and when you deny there was something else, that isn't right. Now, whether you also need to put it to Mr. Baton, well, Mr. Baton, that denial is so implausible, I suggest to you that you were lying, maybe a matter of preference. But one cannot, in my submission, pussyfoot around the point that if the CMA is right, what is set out in the contracts and signed by the directors and heavily negotiated over a period of many, many weeks and months is an incomplete record of what was actually agreed. Now, in my submission, if it's refracted through that lens, it is very, very difficult to avoid a cover-up.
The cross-examination is going to miss the date, and this is all a sham, you're lying. The supply agreement isn't the full extent of it. To which your answer is nonsense, of course it is, that's the end of it, full stop, period. Then the cross-examination descends into, okay, let's look at context. Let's go in through looking at the price of supply, the incentives, the leverage, what impact this was going to have upon you. And then the submission to the tribunal is, well, of course, Mr. Baton denies it, but actually look at reality, which is staring you in the eyes. We've been through the cross-examination. This is the collateral economics, if you like, pared down to its bare essentials. Isn't that another way of just putting the same thing? Why do you have to say you're lying about the supply agreement? Everyone knows what the answer is going to be. And he set it out in his witness statement.
Well, there is a danger of being too reductionist about this, because in a sense, if we go down the route of, well, it's predictable witnesses will say in trials, why then bother with cross-examination?
But we're not talking about an absence of cross-examination.
Well, in my submission, we have two contracts signed by directors, negotiated over quite a lengthy period, and it is unavoidable if the CMA is right that the directors who signed those contracts, the General Counsel and the others, including Mr. Baton, who were involved in their negotiation, at least someone there, and frankly it can only be Mr. Baton, was effectively laughing behind his hand because he knew fine well the contract was not the real agreement. There was a different and broader understanding that went
I don't think anyone disputes
beyond
that. The
the
question
contract.
is, how do you approach it by way of cross-examination?
That was the case. And Mr. Baton knew. He knew that's what was being put to him. because his own witness statement does that, and throughout his cross-examination, and even when the president is cross-examining, the president actually says to him, I think at least twice, puts a question to him, says, "I know what your answer to this is going to be." Because everybody knew that Baton was denying this. He was denying anything. He denied that there had ever been any collateral understanding of any kind. Question, was the collateral understanding put to Mr. Baton by Mr. Dimitri? Well, the answer to that, it seems to me, only allows for one answer, which is yes, it was.
What was
In a number of passages which were shown to us on Wednesday.
I took the precaution of reading his witness statement. The first paragraph says there was no understanding. There was no nod wink. I understand what your CMA is saying. There wasn't any. And then he says in paragraph 2 there wasn't any. And by the way, in paragraph 3 there wasn't any. He says it hundreds of times.
Yes.
He knew exactly why he was giving evidence.
Well, that is exactly why he needs to be challenged in the plainest possible terms. Well, hang on, Baton.
But he was put.
That's not true.
To him several documents in which the contrary had been said, and he said, "Yes, that's what I said."
Well,
that's quite a good answer.
let's look at what was actually put, rather than debating this in somewhat abstract terms. Well, can I just give you a couple of references before we get to what was actually put to Mr. Baton? Now, as your lordships, I think, may have apprehended, Sinven and I think Advance, and some of the other respondents, had grounds of appeal saying, we don't understand how the unwritten agreement is said to differ from the written agreement. That was a ground of appeal in the proceedings below. And if I can just give you two references as to how this was teed up at trial, we can first of all go to...
Sorry, I don't understand the point. Just help me say that more clearly for me.
Well, I just want to show you...
What's the point you're... which ground are you... which issue are you addressing now?
Still on issue 1A and 1B.
1A
and 1B.
And 1B together.
I want to show your lordships our appeal below and how we put the point on the lack of clarity between the written and the unwritten agreements. So it's in the unagreed upon volume 1, tab 12.
I mean, you know, I don't want to be unhelpful about this, Mr. O'Donoghue, but I completely understood Mr. Brealey's submissions yesterday. Mr. Brealey was saying that what wasn't put was a lot of commercial background, which, having read Mr. Baton's witness statement, I now understand was highly complex, showed him as a man interested in taking over companies and the corporate situation and the corporate realities. And it was not put to him that all that meant that he actually didn't have the necessary nod or wink or understanding. This was a fast-moving commercial situation in which no such agreement would make sense, and that wasn't put to him.
Yes.
Now, what you seem to be coming back to is a rather more reductionist point of view, which is that it was all very unclear what collateral understanding meant. Well, you know, that you'll have gathered from the three members of the court over 3 days nearly, is simply not understood.
Yes. Well, Lord, that's very helpful, I may say so. What I'm saying is it is clear what the CMA, at least now, says is the collateral understanding.
Yeah.
The point I'm making is a different one, which is when one puts that side by side with the written contracts, it is totally unclear what the difference is. And that's the bit that was not put.
Well, I did actually raise that with Mr. Turner. I said, why are these agreements not themselves?
Well, it's a very good question, my lord. It's a very good question.
And Mr. Turner maybe didn't give me a clear answer, but he said he didn't have to. I think he said I don't have to show that. And we've chosen not to show it.
Yes.
So you say, well, why does it matter? Because even if they are anti-competitive, the external collateral understanding that they seek to establish would be anti-competitive, right? So they have chosen not to say, and I can see the argument. I can see why they've not taken on the burden of showing that the written agreement was itself anti-competitive.
Of course, at one stage they did say that.
Sorry, which at one stage
they did say.
But I can see why I mean, you know, you may remember, I put it to Mr. Turner. I said, look, on day one, you've agreed to stay out of the market in return for a bucket of money. even if it's a smaller bucket, than it became after 2 years.
Yes.
And he said, well, you know, and he didn't really answer that point. But they don't take that on now.
No.
Why does it matter? Why are you focusing on the written agreement as having to be lawful or unlawful? It doesn't matter, because the external understanding was unlawful if it existed, and was not unlawful if it didn't exist.
Yes.
And obviously it did have to be put in cross-examination in some shape or form,
Yes.
to be fair to Mr. Bacon.
Yes. Well, that's very helpful, I may say so. The other aspect of fairness in my submission is that if the written contracts are not objected to, in fairness to Mr. Bacon, you have to put something to him and make clear that there is something different and broader to the written contract. So to put it another way, if all that is being put to Mr. Bacon is, well, you're implementing the contract, that is insufficient. Now, I'm going to show you, I want to give you 2 references, then I'll show you how.
Okay, so I get that point. So if all that was put to him was you were implementing the contract and you stayed out of the market under clause 2.2.
Or something coterminous with the contract.
Right.
So what do you mean by coterminous?
Well, if it's being said to Mr. Bacon, well, you agreed not to enter the market, one obvious response to that is, well, yes, see clause 2.2.
And if there was a subclause to 2.2 which says you will not exercise your otherwise unfettered right to enter on 3 months' notice provided we offer you shed loads of money, would that have made a difference to the supply agreement? Presumably it would. That's the difference, isn't it? It's how the power is exercised.
Yes.
And that's not written down in the agreement.
Well,
And that's a big part of the financial incentive of both parties. Or might be, that's what's said.
well, that's helpful. What we've done actually is put a 1 page on a table, the comparison. It may be actually a more useful way to
Comparison of,
the written stuff with the.
is this the
with the
document we
collateral.
got earlier?
Oh yes.
This is one you prepared earlier.
Sorry, we don't have this yet.
Right, we've got this.
So Lord, on the right-hand column, we've got the contract. On the left, the alleged collateral understanding. So in the first row, collateral understanding, Auden would supply AMCO with 10 milligram on terms that amounted to monthly payments or value transfer. And then you see on the right the very low price. That is a term of the contract. I mean, it is plain as a pikestaff that the so-called value transfer is in the contract. And then likewise, second row, in exchange for these payments, AMCO would not enter the market independently with its own tablets. And again, clause 2.2 says exactly the same thing,
But so what?
subject to the right.
What is this designed to demonstrate? That what was being alleged as the collateral understanding was no different from the written agreement, or what?
Well, unless what was being put to Mr. Bacon went beyond the written stuff,
Well,
cross-examination
we've
doesn't
already
even get on the ground.
established in discussion that it is said to have gone beyond this.
Beyond the written document.
Well,
So
my
what
lord,
is how it goes beyond is obvious. There's a contract that says you can terminate this 2.2 arrangement, and then they have collateral rights under 17.2, and there's an understanding that says we will give you 2 years without entering the market, effectively.
well, let's look at what was actually put. 'Cause in my submission, that was not put. Can we first of all go to Mr. Baton's cross-examination. Okay, can I just give you before two references? This is important. So at the start of the trial, the CMA was warned by both the appellants and the tribunal that they need to make clear in cross-examining the witnesses when they're referring to the agreement, are they referring to the contracts or to something else?
Well, there was the 10 milligram. They called it the 10 milligram agreement.
Yes, as an umbrella term.
Yes.
Yes. And can I just give you those two references?
Which document are we in? H2.
We're in. We can pick it up in H3. It's
H3.
reproduced. It's H3 paragraph 51. It's in volume 1 of the core bundle.
So H3 para
51, my lord.
51, thank you.
And it's internal page 42. It's in page 400. Oh my God. You see about 2/3 of the way down, Mr. Brealey. He says, his third line, some confusion as to what actually is the agreement that is alleged to infringe the competition rules. We know it's an agreement not to enter, but in the light of CMA's written observations, there's still a degree of confusion as to what their case is in the agreement. I think,
Sorry, I'm not clear where you are.
my lord, it's
Page 42.
Paragraph 51.
No, I've got the quotes, but where's the which number? It starts
8.
with the president. How far down?
it's about
Number 8.
it's the
Number
first
8, thank
the
you.
first Mr. Brealey.
Got it.
So he says there's some confusion as to what the agreement is. He knows the agreement not to enter.
Yeah.
The case has to be put squarely to the witnesses, and then the president intervenes over the page.
Mm-hmm.
I'm going to expect that from the witnesses we know where the battle lines are. What the side agreement was is something that does need to be put to the extent it is different from the written agreement. We know where we stand. So when the witness says, we all know, when the witness says, no, it was the written agreement, nothing else, we know we're not tilting at what we're tilting at in terms of the battle lines. And Ms. Dimitri says that is understood.
Yeah.
Now, if we then look at the cross-examination, if we go, for example, to day 3, Mr. Baton, in the second supplemental bundle. In hard copies, volume 2, tab 7, page 611.
Page
611. 608 in your version. So it's lines 7 to 18. It starts, do we have plans? Do your lordships have that?
Yeah.
And you see the quotation. So this is Mr. Dimitri cross-examining Mr. Baton. The batch it's in the middle of the page at 12. Batch manufactured at the end of last year is now packed. No intention to release it due to contractual reasons. And she says the contractual reasons could only have been a reference, could it not, to the agreement with Auden. And he says yes. And then starting line 18 and then over the page, you see at the top of page 91, there's another reference, the batches will not be sold for contractual reasons. And then 615, line 4,
615.
612, my lord, in your version. This is important. It starts at line 4. Just a couple of quick questions about the contractual arrangement.
Hang on, I think we're on the wrong page.
Well, it's internal page 94, if that helps.
Yes, I think it's probably better to stick to that. Yeah.
So the CMA says, just a couple of quick questions about the contractual arrangements. Now you'll see over the page at 95 there's a luncheon adjournment, and the sum total of questions on the written contract I work out is something like 2 or 3 minutes. But let's look at what's said. So this is the second written agreement. So it is said there's a clause that if Amco entered the market with its own product, it's required to give 3 months' notice and had the right to terminate. Yes. And at line 13, they open up the contract. And he's asked to read clause 2.2. Then he's asked at 21, so there's a 3 months notice provision. Yes. Then he's shown the termination clause at 17.2. And then over the page at 95, you'll see what is put to him. Effectively, well, if you enter the market, the contractual termination right will be exercised. And he essentially agrees with that. And then you see at line 15, that is the end of the cross-examination on the contract.
What do you deduce from this? Because this is some 60 pages after that portion of the cross-examination transcript that we were shown earlier, where there is the analysis of the financial relationship between the parties, which would, in effect, which is the collateral understanding, I think on the CMA's part, prevent the option ever being exercised.
Correct.
So, and that's the added element, isn't it?
Well,
theoretically, you've got an option which is being explored.
Yes,
but this is...
It's the passage that really begins at page 22.
Yes,
and
but
it goes on for about 10 pages.
Yes.
And when, in the passage you were showing us just now, Mrs. Dimitri comes back to, say, at line 8, sorry, we answered it, where he says they probably would have terminated as we launched because there would not have been any benefit to them, would answer no. That seems to me is a reference back to the previous cross-examination.
Yep.
This all has to be looked at in the round. You can't just isolate this as the only place where the actual written contract was addressed. Because there's a whole load of cross-examination where what was put to Mr. Baton, at least as I read it, was that there was a collateral understanding.
Well, that's fair, but of course, what is not being put at any stage is, well, Mr. Baton, you had a unilateral contractual right to enter with 3 months' notice, and you agreed with Auden that you would never exercise that right. What needs to be put to Mr. Baton was, well, there is a 2-year non-compete in clause 2.2, and in fact, what you agreed with Auden was something that lasted 3 years.
Okay, let's assume that's correct. It wasn't as explicit as that, but when one reads, I mean, the subtext to this, and indeed the broader question is, to what level of granularity must any counsel go in putting a case when, I suspect from the CMA's part, it was a statement of the be obvious that was the context. After all, that's what is said in Mr. Baton's witness statement. I know exactly what the CMA's case is, and actually this is all commercially rational. So does that have to be put in a formal sense, or do you just get stuck in what you're saying just doesn't add up, it doesn't stack up?
When one has formal contracts signed by directors with an entire agreement clause, heavily negotiated, in my respectful submission, you do have to put fairly and squarely to the witness what is written down in those contracts is incomplete and an untrue reflection of the real bargain. And there was no ducking that point in my submission. And it is the Master of the Rolls point. It is far too generic. And it is not merely generic in the sense, well, it's somewhat unclear. There is a much more acute point here, which is with these written contracts that are not objected to, you have to put to the witness in the plainest possible terms, hang on, Baton,
Okay.
There was a non-compete more than 2 years. Hang on, Baton.
Okay.
Your
So-
unilateral right. There was no universe in which that would have been exercised. And it's all left hanging there. And in my submission, elliptical language around collateral understanding or, well, no need to put it because we knew he would have said, that isn't good enough. As Mr. Brealey said, we have 9-figure quasi-criminal penalties. We have directed disqualification. We have a titan of this industry who's been CEO for 4 decades of some of the largest generic companies in this country. And in my submission, it is beneath the dignity of a public authority to shadow box around these issues, not to put the point in any fair way to the witness,
Can I just test
and
your
effectively airbrush the contracts.
fairness? So, I mean, you can all disagree and every counsel cross-examines differently, but the test here for us is unfairness of procedure, and that's a point of law which a court must itself decide. Was the procedure unfair? What happens if we do take the view that Mr. Baton, as per his witness statement under their evidence, was absolutely cognizant of the CMA's case? So putting formal statements to him might be said, maybe it's bad practice it wasn't put, but it has no impact on fairness, because he absolutely understood the context of everything that was put to him.
Well,
Now, that may be right, it may be wrong, but if we come to the conclusion he was in no doubt about what the battle lines were, does that affect your analysis?
Well, my Lord, the critical point in my view, and in a sense, the debate we've had for many days now around the metaphysics, or are the written agreements objected to? Are they lawful, not unlawful, or unlawful? In a way, that exposes very neatly the problem. Because if in this august company we've been debating for some days what on earth is the difference between the written and the unwritten stuff, it is not fair to a lay witness who is not a guru in competition law to say to him, well, Baton, you agreed not to enter. That is not good enough. He has,
Why not? If he understands perfectly well what the CMA's case is. I mean, this was an incredibly sophisticated witness who'd been in the pharmaceutical industry for over 40 years. He knew jolly well what the CMA was saying. As my Lord the Master Ross says, his witness statement is absolutely full of stuff about how he didn't have a collateral understanding as alleged by the CMA. And even when the President is asking him questions in that passage where he talks about apart from the threatening behaviour, he knew jolly well what was being alleged.
well, my Lord, in my
You
submission,
didn't have to have it spelt out to him that this was something beyond the written contract.
well, my Lord, in my respectful submission, a lay person would not understand the finer points of a non-compete in competition.
Mr. O'Donoghue, we're all going to have to decide that at the appropriate time.
Indeed.
I have noted for the first time one of the points that you wish to add to Mr. Brealey's list of things that weren't put. And I would like to know, because time is getting on,
Yes.
whether there are any other things. And I have noted that it was not put that he had a right under clause 2.2 to terminate on notice, and you agreed that you would not exercise that right at all.
Yes.
Now, is that correct? Is that the point you're making?
That is the point.
And is there any other point that was not put in addition to Mr. Brealey's list, which I hope I do understand?
Yeah, well, the materials, the cross-examination I've shown you, the continuous references to the contractual arrangement, that also covers the ASICA.
Sorry, let's not have shorthand. Let's
The-
say expressly what is not put.
The 3 references I showed you to day 3, the contractual reasons, your Lordship recalls that?
Yes.
That is putting the ASICA suspension. And it is an inadequate way of putting the case to Mr. Baton to say, well, Mr. Baton, the reason you suspended is because of the second written agreement. Again,
So, ASICA suspension.
it's been put to Mr. Baton, the reason you suspended is because of the contract. The contract is not objected to. That is an inadequate way of putting the case.
So to put it in positive language,
You've got to say,
it should have been put that he cancelled the Ithaca production because he had a collateral understanding with Auden
yes,
that he would not cancel the supply contract with 2 years.
yes. And what's actually been put to him is the reason you did this is the contract, which is my case. Now, and indeed, one can go further, because of course the 3-month entry right is important. There's a unilateral contractual right. But in fact, the overarching structure of clause 2.2 is for up to 2 years, that was a contract duration, AMCO could agree not to compete. Now, if in isolation that is not objected to, if AMCO can sit there for 2 years, take the Auden supply, and that is not an object agreement, you have to put to Mr. Baton, well, hang on, Baton, it's 3 years or 4 years or something different. And that's not being put either. Now, in a sense, that collapses into the 3-month notice period point, but it is actually something broader. Again, on the face of the contracts, there was a non-compete. So to put in cross, you agreed not to compete, is, in my submission, woefully inadequate.
So, can you show me where the tribunal
Yes.
makes the point,
Yes.
either the first point or the second Ithaca point?
Yes. One moment. I'm coming to that now. Can I first show you the? So we're now in the post H2 period. Can I show you the? First of all, the 2-day hearing on due process, because this is important. It's in supplemental volume 6.
So we're looking at transcripts now.
Yes.
So this is where you said this to the tribunal, not where the tribunal said it.
Well, I'm teeing up the point a little bit. It's important
Okay.
to see how we got there.
Can I just ask you a question? We discussed a couple of days ago about the extent to which there was forewarning of everybody as to what was going to happen in H3. Now, we know that the question of dishonesty and sham and intention, because that was flagged in H2. To what extent was there any pre-identification from the CAT as to which issues it thought hadn't been properly cross-examined on? Or did that just come out in the course of the hearing?
Well, I'm going to come to this in a bit of detail. It's quite important. But in my submission, what happened, of course, as you'd expect, there were detailed written submissions before the 2-day hearing. There was a 2-day hearing. There was a 26-page post-hearing submission from the CMA, which I will show you, articulating their case on the collateral agreement. And the submission I'm going to make to your lordships is, having seen this 26-page document, attempting to articulate their case and the difference from the written agreements, the tribunal at that stage was not simply concerned with things not having been put, but that actually the clarity of the collateral agreement, in the sense of it being a contradistinction to the written agreements, was completely opaque.
So to answer my question, and it's a very narrow procedural question, the only thing flagged before the hearing was that in H2. But during the hearing of H2, which includes submissions, these broader issues came out.
In my submission, what was called a due process hearing, transmogrified.
A re-review of the evidence.
Indeed. And of course, these go hand in glove, because...
What did you say, Mr. O'Donoghue? It transmogrified into what?
A hearing that was not just concerned with due process, that actually went to the fundamental clarity of the CMA's case and the collateral agreement, which then led to a review of the evidence.
Which they had already made findings upon, which were provisional, contingent upon their concerns about sham and intention and dishonesty.
Yes, yes. But in my submission, these go hand in glove, and I'll show you this, because...
I mean, for good or for ill, it exploded in H2 and went way, way beyond anything foreshadowed, H3, went way beyond anything shadowed in H2. Now, that may or may not be a bad thing.
Well,
but
it's
that's
what happened. It's what happened.
Yes, okay.
So I want to tee this up carefully because it is very important. Of course, there is a fair question of how do we get from 2 to 3, and the interlude is important to understanding both what happened and actually my course of mission today.
I mean, do you accept that in H2, what they said was, these are our conclusions on all the evidence, but we're concerned that it was not fair to Mr. Bateman not to put to him that he's a liar and that he's dishonest. We think he is dishonest. We've just found so. We think he did enter into a collateral understanding. We think this and that, but it wasn't fair.
Well, it was certainly that, but in my submission it was more than that.
Right.
Because, of course, the tribunal wasn't prejudging the fairness point. It was saying, we think
May not.
there may be a fairness concern.
Yeah.
One manifestation of that, of course, is dishonesty. Another manifestation, which Mr. Breeding focused on more, is, well, did you challenge denials? Did you put your case? So there's a more attenuated form of unfairness.
What I get out of H2 is the recollection of it being about dishonesty, but you'll show us where it was all about putting the case. Because my understanding is that transmogrification was H2 said, these are our conclusions, we think he was dishonest, we're not sure it was put to him that he was properly, so
yes.
We need to look at that.
So
and then when it comes back, it all turns into what you might describe as a bit of a bigger production.
yes. And the other point is very important, which is my point. By the time we get to H3, the tribunal is deeply concerned as to the clarity of the collateral agreement case.
We understand that. And just in terms of law, I'm just gone back to 153 and 157 of H2, where they're explaining why they have a due process concern. It's about those two things, sham and intention,
Yes.
which are related to dishonesty.
Well, that was the genesis.
That was the genesis.
Yes.
So that was the trigger for H3.
Yes.
Now, I think we all agree that when H3 occurred, it grew.
It grew like topsy.
Yeah,
Yes.
probably not allowed to say that anymore.
And again, in my submission, the lack of clarity on the collateral agreement was what caused all of this to blow up. Now, I'm going to give you the references. We first go to the day one of the due process hearing. My Lord, it's in Supplemental 6, tab 32.
I mean, can I just be clear about the implications of H2 being having as a trigger for H3 dishonesty, sham and intention? It's because they had clear, unequivocal findings on everything else. And yet, when we get to H3, and again, I'm not saying it's right or wrong, it's just what happened, then all those clear, unequivocal findings of flagrant violation suddenly become unravelled.
Well, my Lord,
Is that a fair, albeit pejorative, way of describing it?
My Lord, maybe slightly tendentious. First of all, of course, is Mr. Brealey's point that they say in several places H2 was essentially based on the documentary evidence that needed to be triangulated with the evidence in chief and the cross-examination. So that's obviously one point. And again, when the CMA was asked to explain its case, that put the cat among the pigeons. I'm going to come to that. It's very, very important. But, my Lord, again, at the risk of stating the obvious,
I don't think anybody...
no one on this side commended this course of action.
No, we understand that. We all understand.
We are where
There's
we
an
are.
element of we are where we are.
Yeah.
And we're trying to all get our heads around that.
Yes.
It's not something we need to get into.
There is an explanation.
Right.
It wasn't that the cat got out of bed one day and decided, well, let's have another go. There is a backstory here that is important for the points I made today.
So just so I understand what we're looking at here, there had been, following H2, which was handed down
in late September,
but closed on, I think, the 23rd of September last year, or 23rd, in September, 29th of September. About a month later, there was a 2-day hearing, consequentials hearing, on the 26th and 27th of October, at which the President asked for some written submissions.
the written submission before the hearing.
No, these ones we're just looking at, which you referred us to at tab 32, are subsequent to that.
Oh, sorry, in your bundle is tab 30.
Which tab?
That's 30.
I think I said 32. Right?
So there,
30.
so there were obviously a series of skeleton arguments before the 2-day hearing. There's the hearing itself, and then there's an
Right,
important...
this is the transcript of the hearing.
Yes, that's, my lord, in my 32, 2566.
Hey, which page of the transcript? Don't use the bottom numbers because they're all over the shop. But which page of the transcript? It's in the top right.
I think it's page 9.
Page 8 and 9.
Which page are you on? I'm afraid I'm lost.
My 2572, which is page...
So this is
So the-
what, day one of the
Page,
hearing.
day 1 of the due process hearing.
Page
I mean,
8.
Page 6.
the first page, within 5 seconds of opening the hearing, the President says, I'm giving everybody leave to appeal,
Yes,
whatever happens. That's a bit of an unusual start.
yes. It was prophetic.
And then he goes on to say this is all about dishonesty. And
Well-
we're going to have a closed hearing because of that.
Well, in part. So, my lord, if we look at the bottom page 6, for example,
Page 6.
internal page 6, it's my 2572. So the President is saying, one of the things we continue to find difficult about the CMA's position is precisely what their case on the collateral agreement is.
So where's that? Which line?
Well, it's at line 23 at the bottom. So the President says we don't really understand your case agreement. Then Mr. Jones, as it then was, he says yes. And the President says, going beyond the first and second written agreements. If you then look over the page at 23, the bottom of the page, it is put to the CMA by the President, well, what do you mean by the 10 milligram agreement?
Sorry, I'm not where.
Well, look, forgive me.
Page 8.
It's internal page 8, line
The
23.
unlawful agreement, yes.
The President says, what do you mean, CMA, by the 10 milligram agreement? And Mr. Jones says, the unlawful agreement.
Just before you go on, I mean, just go back to page 7 of the transcript at the top. Really, the bottom of page 6. One of the things that we continue to find difficult about the CMA's position is precisely what their case on collateral agreement is. We accept, of course, that we have made our position clear, and that is not going to change because we have made our position clear in the judgment that we are subject to submissions regarding as final. They understand what how can they understand what the agreement is and say they're not going to change it subject to what happens? Because we're clear and yet say we don't understand.
Well,
Maybe there's no answer.
indeed.
I mean,
Well-
are we getting any submissions from anybody about whether this process was appropriate at all? Because it does seem to me pretty dangerous, really, to give a judgment on the merits and then come back and have massive amounts of argument about the merits. I mean, leaving aside the dishonesty and all the things. I mean, I mean, speaking only for myself, if I were to be writing a judgment in this case, which obviously is possible, I would want to be able to say whether this process was appropriate or not. And I perhaps need just to hear a few basic submissions on that.
Well,
I mean,
my lord, Mr.
you know,
Mr.
normally-
Jowl will deal with that.
I mean, normally, Mr. Giles can deal with it. I mean, normally, in a case, judges sort of decide cases and say, I've decided the case, you go to the Court of Appeal. It's not my problem.
Yes.
This is
Well,
sort of...
your lordship will have seen.
Even if you put in a coda saying that you were concerned about whether everything being cross-examined to, you'd say, well, leave that to the Court of Appeal. You can make submissions to the Court of Appeal.
I mean,
Well,
because it's one is put in mind of cherries and fights. You know, once you've decided, you've decided. But here we are, we're sort of, we open a chink with the dishonesty, and then we say, well, I don't even understand the CMA's case which they've upheld.
Well, my Lord, we say that this is what happened. They asked the CMA,
Yeah.
we don't understand your case.
You can agree with us without necessarily abandoning any point of your.
Well, as your Lordships will have seen from paragraph 25 of H3, a number of the appellants, the then appellants, said the tribunal should have stopped at paragraph, I think, 28 of H2, and then had a hearing. So that fell on deaf ears.
Okay.
Again, no one was advocating for.
No. But I mean, we must make sure this kind of thing, it is clear what is appropriate and what is not appropriate. Let's put it that way.
Yes.
Because this is a very expensive exercise for the parties, and you know, I think, as somebody said, the reputation of the jurisdiction is very important.
And the individual.
Yeah,
And the company.
of course.
Yes, I mean, yeah, and what's striking is really picking up my Lord's point, is that at paragraph 133 of the H2 judgment, the CAT sets out in extenso passages from the CMA decision, and then in paragraph 134, it says that Hydrocortisone decision found there was actual knowledge of an agreement infringing Chapter 1 on the part of Auden. We find that the CMA's findings are unimpeachable, and it then goes through effectively what the collateral understanding was.
Yes.
So I'm completely baffled by the suggestion that they didn't know what it was.
Well,
How can they possibly have adopted all those findings and so they were unimpeachable if they didn't understand what the case was?
well, I don't know.
Sorry, probably very sensible answer.
But what is clear from what I've shown you is that by the time of the 2-day hearing, they're saying, hang on, CMA, we don't quite understand your collateral agreement case. And they were effectively, you'll have seen the rider in H3, they said, your case is AMCO will not enter, even if it is able to do so. Mm-hmm. So because of the lack of clarity on the collateral agreement, they were forced to fill in the blanks for the CMA. I'll show you the CMA submission following the 2-day hearing. So it's put to Mr. Jones, well, what's your case on the collateral agreement? He says, oh, it's the unlawful agreement. And of course, isn't very helpful. If I can just show you one more passage. It's on 2586. Internal page
50.
line 23.
So internal page.
It's page 20.
Are you looking at a different document? Because it's very easy to see what the page numbers of the transcript are from the top right.
Yeah, page
Mine
20.
says day 1,
Page-
CH1,
yes,
page
page-
such and such.
Page 20.
Page
20.
20. Yeah.
So Mr. Jones says the common understanding was that there would be a transfer of value, so lines 4 to 6, transfer of value from Auden to AMCO. And then the President of 19 says, well, it is as plain as a pikestaff there was a transfer of value. So that's my point. Well, you've got this low price in the contract. Everyone and their mother knew this was a low supply price. So what does that tell us? So what is happening is that there is a nagging and growing concern that we don't understand how this collateral agreement differs from the contract. I just want to complete that point. We then go to the CMA submission, 26-page document. It's in tab 7, tab 34 of the 7th, volume 7, second one.
Tab 34.
Thank you, my lord. It's internal page 2876.
And this is after the hearing,
Yes.
but
So
before
the
judgment
yes,
in H3.
yes. So this is dated the 6th of November. It's I think 2 weeks after the hearing. So you'll see, my lords, in the opening sentence.
Hang on a second, I think we're in the tab
It's 32, page 2917.
2876. Thank you.
2917.
2917, yeah.
The numbers diverge even more as this hearing goes on.
It keeps me on my toes.
Right, this is CMA's document that they put in at the President's request.
Yes.
Right.
So I've shown you where the President says, well, look, I don't understand your collateral agreement case. Can you tell me more about it? You see in the opening sentence, the President asked the CMA to provide a note explaining the precise formulation of the CMA's case. Now, I'm not going to go through all 26 pages, but you will see it's 26 pages long. You can jump forward. Jump forward to paragraph 5. You will see it covers a pretty broad terrain. There are 5 points. The first one, of course, is the precise formulation. What is the 10 milligram agreement?
This is like closing submissions all over again.
Indeed.
This is 617 and 618 of the decision, which was the point that I put to you.
Yes.
So they're not, the CMA's case, they're simply spelling out our case is a precise formulation of our case, is as set out in 617 and 618 of the decision.
Yes.
I put that to you earlier on. That's as clear can be.
Well,
It has 2 parts.
yes. My lord, I don't want to go back down that rabbit hole, but that is clear. What is not clear is how does that differ from the written contracts. That's the missing bit. But in any event, I'm trying to show your lordships what happened. And as Lord Justice Green says,
Does this take us any further than the point which you've clearly identified, which is to what extent is it necessary in principle to go beyond putting the clear terms of the contract? I mean, that's almost a matter of the procedural fairness judgment for the court. And then we've got to say, did she or didn't she?
Well, I'll come very shortly to make my 3 short submissions as to where this takes us.
Okay.
Can we just round off what actually happened? So there is a gnawing, growing concern that we don't understand the case. But there are 4 other points in this detailed submission. You see, for example, 3rd point, ASICA, 4th point, shams.
Yeah.
And actually, it's only the last point under 5E that is about dishonesty. So 80% of the points are not about dishonesty.
Yeah.
So,
Sorry, where are you looking to these 4
well, it's
points?
paragraph 5 is a summary of the
But
document.
that's what he asked.
Yes.
Yes.
They're making the point, though. They make the point in paragraph 3. They make the point about all the findings that have been made in HC2, which is the polite way of saying we don't really understand why we're being asked all this because you've made all these findings, so you must have understood what the case was.
Yes.
I think that, that's how I read it anyway.
Yes. Well, they certainly are saying that. But anyway, the point I make is that there was an awful lot post H2 that was not simply to do with dishonesty. And in my submission, that helps us understand how we get from H2 to H3, or at least it is part of the explanation. Now, just to give you a final reference, and then I'll show you in H3 where the concerns about the lack of clarity, those findings are made, and then I can quickly make my submissions, hopefully, and complete that before lunch. And then I have 2 very short points, which I'll wrap up very quickly after. If we can go to the 6th supplementary one, one final reference to the so-called due process hearing transcript.
Sorry, supplementary number 6.
6, my lord. And it's in my tab 32.
Well, it almost certainly won't be our tab.
It's our tab 30.
It's a racing certainty.
What page?
30, my lord.
Page 30 of the transcript.
It's 2575.
Yeah, you have to give us the top right-hand
Page.
page.
Page 30, is it?
Page 30?
Page 9.
Page 9.
Page 9.
Yeah.
Yeah.
So this again is the President. So he says, I was remarkably unsympathetic to my point in opening that it was unclear what the collateral agreement was. I am much more sympathetic to the points made in closing, which were exactly the same. So by the time of this hearing, to use the vernacular, the penny has dropped. There is a lack of clarity as to how the collateral agreement is different from the contract. And we then go to H3 itself. We see this made good. And it does, in my submission, very much
Can I
tie
just
in.
ask you this, and maybe again there's one of those questions for which there's no rational answer. On page 9 at the bottom, the President says that when you opened, he wasn't sympathetic. By the time he'd closed, he was more sympathetic. But they didn't then say, well, we find your submission compelling and therefore we allow the appeals. And because you put that sympathetically expressed point in closing,
Yes.
they found against you, and now here we are 6 months later,
Well,
reverting to your sympathetically put closing submissions. There maybe isn't any answer to that.
no one is zealous as a convert.
I mean, I can't help feeling that the evidence must have been taken from philosophers rather than actually lawyers. I mean, this is all about how many angels can stand on the point of a needle. I mean, the fussing, that's why we're here today, page 10, philosophical point perhaps. There's a sense that the CMA feels it didn't have to go as far as quite clearly the judgment considered it needed to. And of course, what all the appellants are saying the CMA needed to, that's the essence, I think. What is the collateral agreement? What's the naughty bit in here? What's the infringing part? I mean, this is sort of agony. But it's about something that's already decided.
Well, the sequence is odd. I accept that. But what is certainly...
I mean, I mean, you know, I want to hear submissions because, and I have to be perfectly honest, it seems to me entirely improper to revisit findings in the way that happened here. It seems to me that the process is skewed. If you've got a problem with what's been put in cross-examination, you resolve it before you resolve the case. You can't do it back to front, because if you do, you get into the problem we've got here, where you end up unpicking your own decision, which is exactly what the tribunal cannot do.
Yes.
What you do one or two things. You either, before the witness leaves the witness box, say to counsel, well, I don't think you put everything you should have put. And these are the things I think you should have put. Well, then if counsel decides not to put them, that's his or her lookout, but at least counsel then has an opportunity to put them. Well, I suppose in the extremis, you might get to the point of writing the judgment and say to yourself, well, actually, now I look at all this in the cold light of day, I feel they didn't put things that they should have put, and ask for the witness to be recalled.
I mean, in the
before you
same
hand down
way,
judgment.
I mean, yes, and in the same way as I put to Mr. Turner that process demanded that he challenged bits of H2 in the way he agreed with in the end, I put to both of you that if you disagree with that, or even if you agree with it, I really would like to hear full submissions on why, because it seems to me very important that what happened here is explained, and this court is able to say that it was right or wrong.
Yes. Well, Mr. Jarl will deal with it.
And if and what the consequence is, of course, because there seem to me three consequences. We allow one or other or both appeals, we dismiss one or other or both appeals, or we order a retrial. And for my part at least, I don't think it's obvious what is the fair and correct solution, which may turn on how wrong the process was, and could be said the parties contributed to it. I mean, by not standing up and making the submission clearly, you must not do this at some point, and if so, what point?
Well, my lord, as you see in H3, it was indicated.
Because one other possibility is that you could have said to the tribunal, this is improper. Somebody could have said, I am going straight to the Court of Appeal without passing go or collecting
Well, your lordship's
£200.
absolutely right.
Yeah.
The conventional course would be two things: not to hand down H2, or hand down H2 and say, try your luck on appeal.
Well, if you don't hand down H2, you can do what you like, really,
Yes.
because you're the
It
master
doesn't
of your
exist.
own procedure. But what I mean, you can see what I'm troubled about. I mean, this really troubles me. What you've just shown me, I hadn't seen it. That when you all turn up, thinking you're doing one thing, you find you're doing something much broader.
Well, I see all of that.
Did you put in
and
submission?
that couldn't be foreshadowed, or wasn't foreshadowed in the coda to H2.
Really?
No.
Okay. Well, it's jolly. I mean, I'm just the point I'm making is it's jolly difficult,
It is.
and it's jolly difficult for this court as well as for you people. And I'm sympathetic, you know, and I want to give everybody the opportunity to have their say. I know we've been interrupting a lot. We'll try and
Yes.
we'll try.
My lord, risk of stating the obvious, no one suggested you should do this.
No one suggested that he should do this. No. But you know, it's not.
We're only asking the questions because we're troubled by in this troubled by the process in this case.
I mean, it doesn't seem to me that the president did it out of anything other than perfectly good motives.
Absolutely.
You know, he was trying to get to the truth and right,
And he was trying to be fair to the individuals.
and be fairness, and you know, I mean, all that's absolutely clear to me transparently.
Yes.
But equally, it's for us to lay down what should happen in such situations in the future, because otherwise we'll have been wasting our time here.
Lord, if nothing else, it was brutally transparent and open. In a sense, what you get from H2 and H3 is a window to the tribunal's internal dialectic. Now,
But that's why I said philosophy. I mean, you get
yes,
you get the twists and turns of of the mind,
yes.
which actually we have to be careful to avoid as lawyers.
Lord, yes. There's a reason the kimono is sometimes not opened.
Yeah. Okay. Good. And look, we'll shut up and let you go. I know you've got. Oh, it's 1 o'clock. All right. Well, I know you want to put crisply.
My submissions.
H2, H3, and then put your submissions.
Yes,
crisply.
I want to show you the bits in H3 where the lack of clarity is recorded.
Yes.
And I have 3 short submissions to make, and I have 2 very, very short points, which I can do. I mean, I hope in 30 minutes I'm done.
Okay. Well, that's fine. Good. Okay. Well, look. Thank you. Thank you for bearing with us. 2 o'clock.